Welcome to Red, White, and Blue. From the right, I'm Paul Bettencourt sitting in for Gary Polland.
And from the left, I'm David Jones.
This week on Red, White, and Blue, a discussion with Arthur Dale Carpenter, the Earl R. Larson Professor of Civil Rights and Civil Liberties Law at the University of Minnesota's Law School, about his new book, Flagrant Contact, the story of Lawrence v. Texas.
Welcome, Dale.
Thank you.
So we're going to be talking about a book that happened, a lot of it happened right here in Harris County.
That's right.
Two guys who didn't know anything, politically powerless people, run into a cop that doesn't like gay men, apparently. Next thing you know, they're arrested, they're in jail. The only reason that they get to a lawyer is that two closeted clerks and a court staff decide to go to a bar in Montrose and run into a politically savvy Democratic guy who finds them a lawyer who's not even a criminal lawyer. Now, how does that kind of case with that type of beginning get to the United States Supreme Court?
Well, you know, it's interesting. I mean, a big section of the book is how you get from an apartment arrest in East Harris County to the Supreme Court. And, you know, it didn't just happen automatically. There were a series of chance encounters and serendipity and a lot of ways in which this case could have fallen apart at any single moment. There was nothing inevitable about an ultimate Supreme Court decision in this case. Let's
set the frame for what actually happened, though, so that everyone that's watching can stay up with it. You've got a situation where you've got two gay men in an apartment, okay?
Right.
There's been a phone call made to the police department, and basically they come bursting into the scene, and so why don't you take it from there?
Yeah, well, you've got actually three men in the apartment that day. Two of them are partners, Tyrone Garner and Robert Eubanks, and then you've got John Lawrence, from whom we get the name of the case, Lawrence versus Texas. And at some point in the evening, after they'd moved a bunch of furniture around, they're sitting in the apartment. They'd done a little bit of drinking, and Robert Eubanks gets upset about something and announces that he's going to go downstairs and get a Coke. So he grabs some change out of the drawer, he leaves the apartment, he goes downstairs, and instead of putting his coins into the Coke machine, he put it into the pay telephone.
Fascinating.
And at that point, he called the Harris County Sheriff's Office and reported to the Harris County Sheriff's Office that there was a black man which would have been a reference to his partner, Tyrone Garner, going crazy with a gun inside of this apartment. So that's a weapons disturbance, and an immediate response from the Harris County Sheriff's Office is called for, and that's precisely what happened.
And the shocking thing that I'm sure occurred to you as you were researching the book was that the deputy here probably did not see sexual conduct. Was that a shocking thing to you after you've researched everything to find out that the entire case was based on a lie?
I was very surprised. I did not go into the book expecting that I would conclude that there had been probably no sex, and certainly that there had been no one witnessing anyone having sex. That's a probabilistic conclusion. It's my best judgment based on the interviews I did. I wasn't there, obviously, and several of the people who were there are now gone. But I interviewed all of the people involved, and putting all those pieces together along with some of the other evidence in the case, that's my conclusion. And in a sense, that's not that rare, because it's not that rare that the police wouldn't have seen anyone, because it's rare to have the police come to an apartment and claim to witness people actually having sex.
But we shouldn't slander the police. This was the Harris County Sheriff's Office, which, by the way, as you document in the book, they do not have a very good reputation.
Well, they certainly don't have a policy that prohibits discrimination on the basis of sexual orientation, or at least they didn't as of the last time I checked. And no training so that the officers know that when they go into an apartment of gay people, they don't start using anti-gay slurs and so forth. That
and Dale, you checked because Adrian Garcia is now the sheriff, and that happened in 2008. So that policy is still not in place, even though there's a Democratic elected official in that job.
I don't know what their policies are now. I'm speaking of 1998, when this case came about and when these two men were arrested. They had resisted having this kind of training and non-discrimination policy, in contrast to the Houston Police Department, which did have that kind of training and non-discrimination policy.
Now, by 2001, this case has worked its way up to the appellate level, which is really kind of the next big flashpoint in the book.
It had worked its way up to the appellate level by then, and it was in front of an intermediate appellate court here in Houston, one of the two overlapping appellate courts. And by then, the arguments had come down to two basic claims. One of them was that in arresting these two men, supposedly for violating the Texas homosexual conduct law, the law had violated their right to equal protection under the law and the Constitution, and it had violated their fundamental right to privacy, to intimacy. And they also made an argument, because they were in a Texas court, that the discrimination, saying that sodomy between two people of the same sex was illegal, but any other sodomy was legal, was a form of sex discrimination, because whether you violated the statute turned on whether your partner was of the same sex or the opposite sex. And two of the judges out of the three on the panel actually agreed with that view initially. And then they were reversed by the full appellate panel.
Well, let's talk about that a second, because it sort of sets up sort of the climate discussion, if you will. That panel was basically trashed at the Republican State Convention, where demands were made that if you want to be a Republican judge, you need to follow the platform, and the platform certainly doesn't allow for you to do anything other than support the sodomy statute.
Well, the Texas Republican platform said that homosexuality tears at the fabric of society, and it contained a provision that opposed the decriminalization of sodomy and there were a number of other parts to the platform. After the decision came down, within a very short period of time, the state Republican convention occurred, and that state Republican convention issued a rebuke to the two judges who had voted to strike down the sodomy law.
Well, what's really ironic is we're doing this interview without Gary Pollan, okay,
Yeah.
because he's here in your book.
Right.
And what's interesting is, and by the way, if you do in the second edition, I was the treasurer, not Paul Simpson.
I'll give you the credit.
Now, all right. So Paul Simpson is a legal counsel, and Gary is the party chair, and basically they're sending out a letter to the local party chairs in the appellate area, saying that they disagree with the decision. Specifically, I think Judge Anderson, who just retired, I think, or just announced that he was leaving this week. And basically they said, I think, if I remember correctly, their grounds were that this is legislation from the bench and it should have been done right.
They argued that they were overstepping their boundaries, that the decision was inappropriate under the Texas Constitution. The state convention called on these judges to, rebuked the judges and called on them to be defeated, and it was too late because they were already on the ballot. I think one of them was not even up for re-election that particular year.
Explain how it is that you were successful in getting, not you, but the case was successful in getting to the Supreme Court as a result of this political torment that they gave these Republican judges.
Well, so after the rebuke came out and there was political pressure applied, the full panel of the Court of Appeals took this case. And that's a panel of 9 judges.
Right.
And those judges, 7 of them, the rest of the judges on the court basically disagreed with the 2 who had been in the majority in the panel, and wrote an opinion saying that there was nothing unconstitutional about the Texas sodomy law, upheld that sodomy law. And from there, your only next step is to go to the equivalent of the Texas Supreme Court for criminal matters, which is the Court of Criminal Appeals.
Right.
And that court then sat on the case, saying nothing about it for 1 year, not even telling the lawyers whether they were going to take the case, whether they were going to order any briefing or any argument or anything else. And then after that year was over, they issued a statement basically saying, we're not taking this case. And that then tees it up to go to the U.S. Supreme Court.
Okay, so it's 2003. What happens in the Supreme Court at that point in time, Dale?
Well, you've got the court accepting certiorari in the case in late 2002, and then you've got to line up your arguments. You've got to refine them further. You've got to write your briefs. You've got organizations supporting each side in the case.
Everybody's filing amicus briefs, whatever, right?
People are filing these amicus briefs, and there were a dozen or more on each side in the case. And then you come to oral argument on March the 26th, 2003, which, if you may remember, was not long after the Iraq War began, just to place it in time. And you had a very exciting oral argument. I was there. I watched in the gallery along with a couple of hundred other people, packed into a fairly small setting, if you've ever been to the Supreme Court courtroom. And the justices then started peppering the lawyers with questions on each side.
I remember they were peppering, Chuck Rosenthal from the accounts at the time.
They peppered Chuck Rosenthal quite a bit, and he was just not prepared. He was not as prepared as he should have been to answer questions, and it really showed the difference in the experience level and the preparation level for the advocates on the two sides.
Did you ever find out why he made that argument when he certainly had better prepared appellate lawyers? Bill Delmore at the time was an excellent lawyer, could have easily stepped up and performed there.
Well, Bill Delmore was his assistant in the office. He was a very good lawyer, very experienced appellate advocate, basically wrote most of the briefs for Harris County in the case. He suggested that maybe he should argue the case, and then he said, other than that, our other option, when he presented the options to Chuck Rosenthal, he said, another option is to have outside counsel, and there were many able appellate advocates outside counsel. Right. And then the third option is to have you argue the case. And Chuck Rosenthal's first reaction was to say, oh, you do it, kind of dismissively. And then the next, Bill Delmore kind of slowed him down and said, wait a second, we need to think about these options. And so the next day on the phone, after he'd gotten off the phone, Chuck Rosenthal tells Bill Delmore, I'm going to do it. I was not able to interview Chuck Rosenthal. He did not accept my request for an
his
interview.
press accounts were probably not strong enough for him.
So I can't get inside his mind, in other words, and find out why he made this argument. I can speculate about it, but I don't know why he ultimately insisted.
Do you think a stronger constitutional argument from that side could have made a difference in the ruling?
It's hard to say. I think, these things are often, what's the expression, baked in the cake from a very early point. It wouldn't have hurt.
Well, when did you know, Dale, either by reading the tea leaves there at the Supreme Court, that you and when did you gain some confidence that this would be a
and
positive ruling?
what was the final ruling? What was
okay. I started to think that this might be successful in the Supreme Court from the time that they granted certiorari. That is, they only grant a hearing about 1 out of every 100 cases that are brought to them. And it would be unusual for the Supreme Court to grant a hearing and appeal, or grant certiorari, as we put it, only to simply reaffirm an earlier decision. It's possible, but that was what gave me a great deal of hope. Having said that, everybody's eyes were on two justices at the time, Justices Kennedy and O'Connor. Right. And it's much the same story today with Justice Kennedy and a whole host of opinions. And when I went to the oral argument, I, along with the hundreds of other people there, were focusing our attention on Justices O'Connor and Kennedy to see if we could divine something from what they were, where they were looking, or how they were smirking, or who knows whatever. And it was impossible. They were inscrutable. Their questions were non-committal. They weren't, using any facial expressions that gave anything away. So you kind of had a sense you were going to win for Lawrence and Garner after this was over, but you could not be sure until that decision came down.
Well, you had the benefit of the Romer decision or rather, I said court observers. Explain to everyone how it is that the Romer decision, written by Justice Kennedy, might have given you even greater reasons to, greater hope, I guess, that this would go the right way.
Well, Romer was a case in which Colorado had passed, in a referendum, a state constitutional amendment eliminating all civil rights protections across the board for gays and lesbians in housing, in insurance, in education, in public education, in employment. Every non-discrimination policy covering sexual orientation in Colorado was removed in one fell swoop in Amendment 2, as it was called. That was challenged on equal protection grounds in the 1990s and went ultimately to the Supreme Court, where indeed Justice Kennedy writing for 6 justices, including Justice O'Connor, voted to strike down that amendment because it violated the equal protection that was due to gay people under the law.
Right, same vote in this case, right?
Same vote in this case in a sense. I mean, Justice Kennedy's opinion is grounded on the idea that there's a fundamental right to privacy and intimacy that covers gay and lesbian people as well as heterosexual people. Justice O'Connor wrote a separate opinion in Lawrence versus Texas in which she argued on equal protection grounds that if the government can go into your bedroom and supervise what you're doing there as an adult, at least it has to do so in an even-handed way. You can't have 2 speed limits for people, and that's effectively what the Texas law was.
Well, we don't want to have a law review story
right
exactly here
because there's a lot of politics with
Dale,
this.
you were yeah, and we'll start with that. Dale, you were in Houston as a lawyer in the 80s, as I recall, and in the 80s there was a very significant political event and controversy that stunned a number of people. Talk about that and how it relates to the 12 years later, the climate in Harris County.
Well, I lived in Houston in the 1990s, but I certainly was aware of what was going on in the 80s. And back in the early 80s, the Houston Gay Political Caucus, or GPC, I think as it was called then, had some successes in local politics and helping elect Mayor Kathy Whitmire and some members to the city council back in the early 80s. This was seen as a kind of growing political force in Houston at the time. And in 1984, the city council, by bare majorities, I think they were 8-7 and 9-6 votes, passed city ordinances prohibiting discrimination in city employment on the basis of sexual orientation. That was strongly opposed by religious and social conservatives in the area who were beginning to react to the successes of the gay rights movement and try to block some of these successes. And they succeeded in getting on the ballot in Houston an initiative that would repeal that ordinance. That launched a campaign in late 1984 going into the voting day on January 19th, 1985. That was really strongly anti-gay in tone and in substance. I mean, there were people coming to Houston claiming that we ought to quarantine gay people. Every part of the business community, the professional community, across the board doctors and everybody were coming out against these ordinances and in favor of repeal. So it's a very different climate from what we've got now, where you've got lots of businesses on the side of equality for gays and lesbians. And that resulted in an overwhelming defeat for the gay rights side, a 4-1 vote, 80% to 20%.
Now, and Dale, you were Republican precinct chair for like 1996 to 2000.
That's right.
So you missed the 2001 referendum, where a referendum was put on the ballot that said effectively no same-sex benefits for
Right.
city employees.
Right.
And so I think, and we're really still at that same point where I think from an economic conservative point of view, people don't want to see tax dollars being spent on that. But I really want to take it up, go from the political side up to now, because quite frankly, it's not every day that the president, makes a major public policy announcement. And I know that Vice President Biden, somewhat outed him earlier in the week by saying that he was in favor of gay marriage. Where do you think this is now? And also, David, I think you've got a nice prop here of a halo over Obama's head. So
yeah,
that's right. So.
This is not an advertisement for any news magazine,
right.
or
nor do I think the Republican Party believes that at this point.
Yeah. Especially not the halo part.
Yeah, that's not the halo part for sure, right?
Well, I mean, where do things stand now? Well, Lawrence versus Texas was an important decision for a number of reasons, and I think it has an ongoing effect on what's happening now. I mean, at one level, these sodomy laws were just about prohibiting specific sexual conduct, which was specified in the statute. I mean, if you just read the statute, that's all it said, nothing more. But in fact, these laws worked to justify and worked as a pretext for discrimination against gays and lesbians in every area of life. So, for example, people could be denied housing. People could be denied a job. The Dallas Police Department used to have a policy of not hiring homosexuals because How could you have a homosexual in a position of enforcing the law when she herself, a lesbian police officer, for example, was a presumptive criminal? They were used in every area of the law in ways to discriminate against gay people. Getting rid of those laws, I think, had the effect, had a legal effect, certainly, in making things more equal for gay people, but it also had a cultural and political effect in that it removed a very strong basis for stigma against gay people. And I can't say that that led to the repeal of Don't Ask, Don't Tell, or to marriage being extended to committed same-sex couples. I can't say that there's a direct line from the decision to those things, but I do think it removed a huge roadblock on the path to progress in a lot of
You really
other
think so,
areas
Dale?
of life.
Because we just had North Carolina,
Right.
and there are 30 states that
Yep.
have.
Right. I mean, that's 30
Right.
votes.
Right.
And your state, Minnesota, is coming up for a vote.
My state is coming up for a vote. That's right. We're going to have we may have 4 votes on the ballot in the election. We probably have Minnesota, Maine. We may have Maryland, and we may have Washington State.
So far, a majority of American states have defined marriage
Yeah.
as one man and one woman.
Right.
So obviously that's some of the backlash from this, and I would say backlash. I think that's more of a fundamental definition that the American public is still voting for. President Obama is trying to change that at this point. So where do you think the politics will play out, or how will they play out in 2012?
Well, it's hard. In 2012, I think we're going to have a series of much closer votes. I think in Minnesota we're very, very close. In Maine, I think there's a very good chance that we'll have the first popular initiative vote for gay marriage. I'm not as certain about Washington State or Maryland. I just don't know what the polling says there. I mean, a couple of things going on. Number one, in the last 10 years, you think back 10 years ago, we didn't have a single state in the union with same-sex marriage. There was no such thing as a civil union anywhere in the United States. It was radical for Vermont to have civil unions. Huge majorities of the American people opposed gay marriage when they spoke to pollsters. We're now at almost 50-50, around 50-50 in supporting same-sex marriage. That has not yet translated into a victory, as you point out, in any of these state referenda. But it's a matter of time, in my view, because if you look at the polling of younger people, especially people under 35, support same-sex marriage with rates of about 70% now. It's true of Democrats. It's true of people in my party, the Republican Party, your party as well. The younger generation sees this as a matter of individual liberty, of limited government, of giving people more responsibility in their lives. So I think there's a shift going on. Whether we've reached the fulcrum in 2012 or whether it's going to come in 2014 or 2016, I think it's coming.
Well, there's economic arguments about same-sex benefits, and I think that's what the heart of the 2001 vote in Houston was about. But there's actually
You mean the expense to
expense to be able to for healthcare expense, right?
Yeah. Well, on the other hand, if you look at some of the Congressional Budget Office, for example, did an analysis back in 2004 on the effect on spending from having same-sex marriage all over the country, and they estimated that the federal government would save about $1 billion a year if there were nationwide same-sex marriage, because when people are married, they tend to take care of each other and provide services for each other rather than relying on the government to do so.
Now,
that could be. Now, I'm not proposing this as a way to balance the budget.
That would be another story.
We'd have to have a lot more than that.
There's really interesting things because you've got Lane Lewis, who's now the current Democratic Party chair, and you've got Paul Simpson, who after Gary Pollan fired him, is running for
after this.
After the release of that letter. And he basically went out and said that it was Gary's fault on a press release. So clearly he was retired. They're both running for party chairman. One's already had the job. The other one wants the job. I predict, it may not be a close vote because there's a gentleman by the name Jared Whitfield who has the job. But it's just fascinating that all these players are on the ballot in 2012 in Harris County.
Well, I don't know. Okay. The mayor's election isn't this year, but of course Anise Parker is now the mayor. She plays a big part part in,
She does.
in
She
this
does.
book.
We only have a minute, Dale. What's been the reaction to this book as you travel the country?
It's been fantastic. I think people didn't understand the complexity and the nuances in this story, and the critical reviews have been terrific. The New York Times, the New Yorker, the New York Review of Books, all
You
of
had
the
to have been
Houston
blown
Chronicle.
away by that, by the people that have reviewed it so prominently.
I have been stunned. I mean, they're fantastic reviewers, very respected civil rights professors and historians, including at the University of Texas.
If you print a second edition, would you at least make the change on page 172?
I'll put you in there. I'll put you in there.
But and the other thing is, I'll predict a second book, because with 30 states passing the constitutional definition, this is obviously going to be a debate for another decade or two.
I think it's ongoing. I agree.
Dale Carpenter, thanks for being with us today. A great opportunity to talk with you, and come back again.
I will.
We invite you to visit our home online at HoustonPBS.org. Click on the local program bar, Red, White, and Blue. Read about our guests. Watch the shows along with our follow-up discussion. And until next time, get informed and get active.